And the interview will be dedicated to, let's say, recent issues in the arbitration field. And I would like to start with, let's say, two current major trends that I myself see in arbitration today. That is transparency and diversity. So looking to transparency, according to the ICC note to parties and arbitral tribunal on the conduct of the arbitration under the ICC rules of arbitration that has been published on the 1st January 2021, ICC is committed to publication and dissemination of information about arbitration. And I quote, ICC awards and or orders, as well as any dissenting and or concurring opinions made as of 1st January of 2019 may be published according to the following provision. And at any time before publication, any party may object to publication or require that any award and related documents be in all or part anonymized. So my first question would be, do parties tend to accept publication of the awards and related documents?
Well, thank you so much to the faculty of the Sorbonne for having me, to all of you for being here, and of course to Pierre Tercier as well for joining us. It's really a pleasure to have the opportunity to chat with you and also to hear from the speakers who will follow. So specifically with regard to issues of transparency and the publication of awards, let me start by asking this audience a question. How many of you, raise your hand, would like to see more awards and have the opportunity to read them? Okay, that's essentially everyone. Now, the second question. How many of you would advise your client, or otherwise, if you are a client, be willing to have your award published? Yes, maybe, depends. And that lies the issue.
Yeah, okay.
Which is right now we have a situation where there is an interest in seeing awards, but the interest of confidentiality for the parties themselves is very, very high. We also know, though, that so many awards become public through various means, most significantly at the enforcement stage, where very few countries consider an award to be under seal or otherwise confidential at the enforcement stage, even if there is an agreement between the parties that that's how it would be.
Right.
And so I believe that it is an issue of time and an issue of trust in the process, because the publication of awards in the process that you just described is the publication of anonymized awards. But right now, the question is, do people trust the anonymization process? Do people trust that we're not just scratching out the names, but still saying French energy company, and everybody figures out who that is? So it's going to take some time for people to see that the anonymization is actually anonymizing, and then I think we will see more publication of awards.
And should they trust in the anonymization process?
I do believe so. I do believe that the way in which we are going about it, and this is in partnership with Jus Mundi, that there really is that effort to assure that it is not just name changing, but really a broader process.
And getting back to this, that the ICC digital library has been merged with Jus Mundi, so access through the old ICC platform is no longer available. Is this one of the ICC's plan to promote case transparency and make decisions more accessible?
Yes, so let me just first speak on the digital library. I am very, very excited about this. I consider the bulletin that ICC publishes 3 times a year to be a phenomenal journal with great articles, great information. And it was until October of last year behind a paywall. And so when we looked to and examined how many people were reading it when there was so much great work going into it, it was not reflective of what the audience could and should be. And so the first step is that the current issue of the bulletin now is always free. So you can go to Jusmundi and always access the current issue. Okay. And that was something that I cared so much about. It was even an idea I raised in my interview for this role. It was something that this is such a great resource, let's unlock it and make it available. And then what Jusmundi does is make all the back issues searchable. So if somebody wrote an article on, the cost of arbitration, and that would be valuable for something you'd want to cite. Absent a search engine, you would never see it, but now people have access to it. So to me, this is really about making sure that the resources are available. In terms of the broader goal of transparency, and many of the initiatives were started by my predecessor, Alexi Moore, one of the key aspects of transparency is that the reasons for our certain administrative decisions and most significantly challenges are provided if any one of the parties makes a request before the decision is issued. I mean, we have discretion within the court, but hard to imagine there would be grounds. I mean, maybe there would be, so we have the discretion when reasons would not be provided. I'm actually surprised in many instances that the parties are not requesting reasons more frequently. There is no delay, I should just add, if parties do request a reason or any one party requests reasons, because we communicate the decision right away and then the reasons follow. Okay. And let me just add one more piece, if I may, on transparency. We have an effort right now that I am calling Transparency 2.0, because I think there is really important aspects about transparency of publicizing the names of the arbitrators, which you can search, and then people can see that this is a very big club, as it were, because you have so many individual people from more than 100 different countries actually serving as arbitrators. Publicizing, or providing information about reasons, making sure people have information. Transparency 2.0 to me is the information about the process readily available? Can someone read our rules and really know the process if you're not a specialist? And of course, this is a specialist field, but we have so many new entrants. We have to be thinking about accessibility of information, utilizing new technology, and thinking about it in new ways.
Thank you very much for this very interesting insight regarding transparency. Maybe we'll now move to diversity, since assuming the ICC Court presidency in July 2021, I guess, your team has introduced various diversity initiatives. For example, in the ICC model letter to parties, co-arbitrators, appointing authorities, and ICC national committees, new language is included to encourage diversity when proposing arbitrators. And if I take the note to national committees and groups on the proposal of arbitrators, I quote, "When proposing arbitrators, committees and groups are encouraged to consider diversity broadly defined, including but not limited to racial, ethnic, cultural, generational, and gender diversity." And there's also the launching of the LGBTQIA networks within the ICC Court in 2021, and the formation of the task force on disability inclusion and international arbitration in 2021 as well. So my first question regarding all these initiatives is the following. From day one of your presidency, you've launched those various initiatives related to diversity. What is the driving force for your passion on diversity?
So we talk about and focus on diversity as essentially key to the legitimacy of arbitration. And we have been hearing that quite a lot, you know, as a tagline. Diversity is key to the legitimacy of arbitration. And I just had to reflect on that to say why. And it all resonated to me actually in January when I was in South Africa with Dlamini Diawara, and before our meetings we had an opportunity to go to the Apartheid Museum, and there was an exhibit on Nelson Mandela. And there was this incredible quote from him. And he had been arrested, and he was advocating on behalf of himself, and he was speaking, and he essentially said, "This court is not legitimate," and I'm paraphrasing because I couldn't say it as eloquently as he had, because I am a black man in a white man's court. And so that was the ultimate statement of why the court process was not legitimate. And so when we talk about essential to the legitimacy of arbitration, we also look at what are the core elements of rule of law. And one of the elements that is included in all types of definition is, do the decision makers reflect the community? And so that is an issue that came up in the United States with juries, for example, where when blacks were excluded, it was at the core. That is not a legitimate process. And so to get to the essence of this, the world is diverse. The business community is diverse. People rightfully can demand that their decision makers reflect that community, that diversity. And so that really is at the core of it. Jay-Z in the United States highlighted this issue a couple of years ago when he was provided a list of potential arbitrators from another arbitral institution and said, this list is not, why should I accept arbitration when there is no black arbitrator listed on this list?
The first time I heard the name Jay-Z in an arbitration conference. Okay.
and so it was amazing to kind of, that was a highlight, and then, but this is ultimately the issue. And at the end of the day, what we're really focused on is not just diversity, but inclusion, that everybody has a way in which they can participate.
And what are the major difficulties your team encounters in promoting diversity?
Well, the most interesting thing is people say, well, the institution should do something. ICC should do something about this. And I say, yes, we should. And the buck does stop here, as we say in the United States. But the court only appoints 25% of the arbitrators. 75% of the arbitrators in ICC arbitrations are either nominated by the parties or nominated by the co-arbitrators to become the president of the tribunal, with typically input from the parties. The ICC court is doing pretty well, with numbers hovering around 40% now of gender diversity. And we are focused, again, on diversity broadly defined, and there's lots of other factors that go into it. The numbers with regard to party nominations of women is made significant steps, but still so much lower.
70%.
Yeah.
70%.
So we could do an amazing job, and then the numbers themselves are not there. So this is where it takes all of us. And we know that the in-house counsel teams are often more diverse than the law firms. So I say to any of you in this room or online, if you are in-house and you receive a proposed list from your outside counsel that doesn't reflect the diversity that you would expect, tell them you want to see a more diverse list. And it's for all the outside counsel to make sure that they're doing that as well.
And as you mentioned this statistic of 40% of arbitrators appointed by the ICC are women, compared to under 30% in 2017. But what about any statistics available on other domains such as racial, cultural, or generational diversity? Do you have any?
So I don't have the numbers on the tip of my tongue, but we've seen significant improvements with regard to generational diversity, and that is not always connected to making sure there are first-time appointments. We are very focused on geographic diversity. And for me, geographic diversity is not just, as we say, African parties appointing African arbitrators, but thinking about African arbitrators for cases that have nothing to do with Africa, thinking about arbitrators from Asia that have nothing to do with Asia. So that's really an element of a focus. For race and ethnic diversity, it's a very interesting question. Again, the calls are out there to make sure we do something to track. We have issues, we have to overcome a bit of a challenge in France. Can you track this? But then the question not only is based on that, what is race and ethnicity on a global level? In the United States, we have our census categories. Those categories make no sense in another country. What is Latino in Latin America? What categories of race and ethnicity would we use in India? So these challenges don't mean we're not focused on it. We're working on it, but and we look for people's ideas on this as well, because we want to make sure that we're focused on intersectionality. We want to make sure that if you track something, you can improve it.
Okay, thank you very much for this insight regarding diversity. And I would like now to move to more technical issues regarding arbitration, and especially the technology improvements in arbitration. And I would like to address the issue of the ICC Case Connect. So in October 2022, ICC announced the launching of ICC Case Connect. Which is, for those of you who don't know, an online case management system for filing and transferring case documents and data. So my first question would be, what has been the users' feedback on the system?
So we now have, in the 5 months that we've been using it, over 200 cases on Case Connect. We have, which is in essence, new cases getting filed, then we are encouraging everyone to use Case Connect. We have some parties and arbitrators wanting to use Case Connect even if they were filed before. And people find the this platform, the ability to have access to the case materials at any time from anywhere, to be incredibly valuable. And what we are seeking is all types of feedback from the in-house counsel, the outside counsel, the arbitrators, as to what may be technical glitches and what may be additional ways in which they want to use the system, because the version 2.0 is already underway. I heard from somebody yesterday who is she was an English QC. Now she's an English KC. She said she couldn't change her initials, and we said, okay, that's good feedback. We've got to, make sure the system can allow for that. There's some other, things that have to get worked out too that are more substantive. Okay.
And any new features to be added to the platform in the future?
Yes, the idea is that it will have have a way in which the parties can interact with it, and information can be generated from it in a much more facile way. Okay. And that it will also be much more connected to the Secretariat's way of communicating to the parties. But all that is to come.
Okay, okay. Thank you very much for these informations. And now I would like to say a few words regarding virtual hearings. So the COVID has affected the way arbitration are conducted. As everybody knows here, many hearings were moved online. But in February 2022, the ICC published its Commission report, Leveraging Technology for Fair, Effective and Efficient International Arbitration Proceedings. But now most of the COVID travel restrictions have been lifted, or maybe all of them. And my question is, have arbitration hearings resumed mostly in person?
I would say, anecdotally, we hear yes. But what I would say has emerged out of the pandemic is this. For case management conferences or procedural issues, it is rare, if ever, that we're going to have those in person in the future. What that means is we can actually now have more frequent case management conferences, and that's something that I'm really advocating, so that the parties focus on issues to be decided throughout the course of the arbitration and not just at the beginning of the case when they don't necessarily have that information. So if there's discovery, disclosure, disputes, and there needs to be a hearing, then all of that can happen by video conference. Now, with regard to evidentiary hearings, I think what we see coming out of the pandemic is the presumption has changed. Before, it was we presume everything is in person, except for maybe one expert who has a medical issue or one witness who's only going to address one small point, and it doesn't justify the costs. That was the way we thought of it in the past. Now, I think every evidentiary hearing, counsel, in-house counsel, everyone is assessing what should we do. It's kind of a blank question without a presumption that it needs to be in person. But I think people do find, especially when there are time zone challenges, with the desire to have a team together, that if you can be in the same room for evidentiary hearing, there's a value to it. What I think we're going to see in the future is that the dichotomy between what I just described, virtual and in person, is going to be the not so simple, and that we're going to see more use of technology for hybrid interaction in in-person hearings. And what I mean by that is especially for in-house counsel. If it's really important for in-house counsel to, let's say, see one or two key witnesses, but not everybody from a team needs to be there all the time, the in-house counsel are going to be demanding that there is indeed an opportunity or way for them to observe the hearing even in a remote context.
Okay, and as you mentioned the in-house counsel, and I would like to address the last question I would like to ask, which is related to the client mindset. Before elected, in the 6th annual Atlanta International Arbitration Society lecture in April 2021, you, Claudia, emphasized the importance of client mindset and engagement of in-house counsel in the arbitration processes. So that is encouraging in-house counsel to be copied into all communications, to attend procedural conference, and so on and so forth. Are there any current ICC initiatives in this regard? Yeah.
So I'm so glad you've highlighted this. Sometimes we hear this as being described as client centricity. And so you're right. I wanted to make sure that every aspect of international arbitration, from the filing of the case to the issuance of the award, has what we're describing as a client mindset. We talk about the parties in an arbitration as users, and in some ways that word is right. They are using our service. Sometimes I think of the word user in English, connotes someone who's using needles, and that's really a bad connotation. Also, when you use something, it's very temporary. You use it and you throw it away, or you use it and it's done. But in this audience, how many of you are outside counsel and in law firms? And do the law firms have users of your services? No. You have clients, and you have relationships. And that is it, and it really signifies something so much more about being a trusted advisor and kind of connected to the institution. And that, from a broad initiative standpoint, is what we're really focused on. And that's every aspect of our service, to make sure that we are accessible, that we are responsive. If somebody isn't wondering whether we've gotten their emails or gotten their letters, that they're getting communication in a timely way. This is really about making sure that there is a level of predictability and that there's a level of responsiveness. And so that really goes to the core of our service. But it's also about making sure that we are constantly hearing and listening to in-house counsel, and that we are also shaping, there's a project underway to shape the way in which we get feedback. Right. Currently, we have a written form, a written evaluation, and someone, the question is, do you want to pay outside counsel to fill out a form? Are we hearing only from outside counsel, or are we really hearing from the clients? And so in my mind, that's really key. I mean, if you ordered food, you probably got a text that said your order has been received. You got a text that says your order is being prepared. You got a text that says your order is on its way, and then the delivery person is, at your door. And did you need all of that information?
Not really.
But did it eliminate concern, or does it help you plan? Absolutely. And we've also come to expect that level of communication all the time. Then, after you've taken a plane, you get an email from the president of the airline. How was your flight? Rate it from 1 to 10. Every single service now, there is a way in which they are looking to assess your needs, and also if you express dissatisfaction, trying to address it. And so thinking about how that can work in an arbitration context is where we're putting our minds.
And regarding clients, and we have here some in-house counsel from, let's say, big companies, big French companies or international companies. But is there any initiative, and that will be my last question, and after that I will leave the floor to the question from the audience. Is there any initiatives with the goal of engaging or educating smaller enterprises about the use of arbitration?
Absolutely. So many of the focus is on large companies. Of course, with the different national committees, named brands, those with large disputes. But the reality is that such a large percentage of ICC arbitrations are below $5 million US. We've now had or about 500 cases under the expedited procedure rules, which was originally below 2 million and now below 3 million US dollars. And so we are really focused on making sure that we have services for low value disputes, and that we are engaging with SMEs and MSMEs, you know, small and medium-sized enterprises and micro enterprises as well. And some of that is, you know, startups in so many different parts of the world. And that's really, I mean, what ICC highlights is that is the real economy. That's the driver of the real economy, and that's what we're really focused on as well.
Okay, thank you very much. Is there anything you would like to add before we leave the floor to the audience?
No, I'm so happy to get a chance to speak with you and happy to answer questions people may have.
Thank you very much.